வணக்கம். இன்று தமிழ்நாடு முழுவதும் தகவல் பெறும் உரிமைச் சட்டம் மூலமாக பல்வேறு பிரச்சனைகளை எளிய முறையில் பாமரர்களும் அறியும் வகையில் தகவல் பெறும் உரிமைச் சட்டத்தை சொல்லித் தருவது மட்டுமன்றி, அச்சட்டத்தின் மூலமாக எவ்வாறு விண்ணப்பங்களை எழுதுவது, எவ்வாறு விண்ணப்பங்களை எந்த அலுவலகங்களுக்கு அனுப்புவது, அந்த அலுவலகங்களில் சரியாக பராமரிக்கப்படாத விண்ணப்பங்களை எவ்வாறு தகவல் மூலம் கேட்டு பெறுவது, இத்தகவல்களை கேட்பதனால் நமக்கு கிடைக்க வேண்டிய பலன்கள் என்ன, இத்தகவல்கள் கேட்டு பெறுவதனால் ஒவ்வொரு இந்திய குடிமகனுக்கும் கிடைக்கக்கூடிய லாபங்கள் என்ன என்பதை பற்றி இந்தியன் குரல் அமைப்பு பல்வேறு விதமான விழிப்புணர்வு நிகழ்ச்சிகளை செய்து வருகின்றது. அந்த வகையிலே ஒவ்வொரு குடும்பத்திற்கும் தேவையான கல்விக்கடன், மாணவர்களுக்கான கல்வி கட்டணங்கள், கல்லூரி கல்வி கட்டணங்கள், ரேஷன் பொருட்கள், ரேஷன் விநியோகம், குடும்ப அட்டை, பட்டா மற்றும் சிட்டா மாற்றுவதற்கான காலக்கெடுக்கள், பத்திரப்பதிவு, கணவனை இழந்த பெண்களுக்கான உதவி பயன்கள், 2 பெண் பிள்ளைகள் படித்த பெண் பிள்ளைகளுக்கான திருமண உதவி பயன்கள், முதியோர் ஓய்வூதிய பல பயன்கள் போன்றவற்றை லஞ்சம் கொடுக்காமல், சுய மரியாதை இழக்காமல், யாரையும் எதிர்பாராமல் தாங்களாகவே விண்ணப்பங்களை அளித்து லஞ்சம் கொடுக்காது எளிய வகையில் பெற்றுக்கொள்ள இந்தியன் குரல் பயிற்சி அளிக்கிறது. அந்த வகையிலே இன்று தமிழ்நாட்டிலேயே பொதுவாக இப்போது நில அபகரிப்பு, அதாவது தனியார் சொத்துக்கள் கொள்ளை போவது பெருமளவில் பெருக்கப்பட்டுள்ளது. அடுத்தவர்கள் சொத்துக்களை தன் பெயரிலே மாற்றிக்கொள்வது, அடுத்தவர்கள் சொத்துக்களை தன் பெயரில் இருப்பது போன்ற கணக்கு காட்டி இன்னொருவருக்கு விற்றுவிடுவது, இதுபோன்ற விவரங்கள் தெரியாமலேயே வாங்கும் அந்த நில உரிமையாளர்கள் அந்த நிலங்களுக்கு பாதிப்பு வரும்போது அவர்களால் அந்த நிலத்தை காப்பாற்ற முடியாமல் அந்த பணத்தையும் இழந்து அல்லல் பட வேண்டிய நிலை வருகிறது. ஒவ்வொரு நில பத்திர பதிவின் போதும் அத்தியாவசியமாக ஒவ்வொரு இந்திய குடிமகனும் அறிந்திருக்க வேண்டிய விஷயங்கள் என்ன என்ன என்பதை பற்றி இந்தியன் குரல் அமைப்பை சார்ந்த ஜி. ராமசாமி அவர்கள் விளக்கி பேசுவார்கள்.
நான் நிலம் பதிவு சம்பந்தமாக ஏற்படுற குழப்படிகளும், அதனால் லேண்ட் கிராப்லிங் பொதுமக்கள் பெருமளவுக்கு நஷ்டப்பட்டிருப்பதையும் தடுப்பதற்காக சில முயற்சிகள் எடுத்திருந்தேன். அதை இப்பொழுது இங்கே உங்களுக்கு ஒரு நோட் வடிவத்தில் கொடுக்கிறேன். Government, being the competent authority, has issued necessary orders regarding the land use for the purpose of planning and development rules for government land, agricultural land, commercial land, residential and commercial land, institutional land apart from the forest and hill areas. From the point of view of validity of registration in sub-registrar's office, private land, that is Patta land, and buildings of the registered organizations such as society, public, private, trust, clubs and quasi-government organizations have to be considered. But this note is limited to private Patta land in sub-registrar's office. Any registration has a buyer and seller. The title of the seller over the relevant property is an important issue. The Registration Act 1908 has no provision to verify the title of the seller. The buyer has to be satisfied about the title of the seller over the property. If the buyer incurs loss on his purchase, he can claim the same from the seller as per written consent of the seller in the document of registration. The seller can be pursued in civil court for compensation of the loss incurred by the buyer. If the seller could not settle such claims or he is not traceable, the loss on the part of the buyer is heavy. Such heavy loss to the buyer can be avoided if the buyer is fully aware of the above circumstances. His belief that the registration gives him the title of the property, even if the seller has no title over the property, has to be clear. Thus, the people have to be made aware of the above circumstances. The object of this note is to create awareness of the people on such issues. The Government of India presented a bill in Parliament, Land Titling Act 2010 and 2011 also, as some states have created their own acts for the purpose. In February 2008, the Ministry of Rural Development, Government of India released National Land Record Modernization Program. It is a landmark decision with ultimate goal to introduce the guarantee of the property to the buyer and to prevent litigations and frauds on the land dealing. Accordingly, the Land Titling Act 2010 and 11 was presented in Parliament and the views of the state government were sought. Even though the Tamil Nadu government is stated to have agreed to the act, no reply is stated to have been received from most of the states. Perhaps the loopholes in the Registration Act 2908 regarding the title of the seller become the more relevant and fraudulent dealing in land registration increased heavily. It is at this time that Transparency International India, New Delhi, decided that we should do necessary awareness program for the people of Chennai on the issue. Accordingly, in these few years, we have conducted some awareness program for the people in Chennai. There are 85 issues for the awareness program of land titling issues, but we are limiting the issues to the only relevant items only in this note. The fraudulent dealing in land registration are rampant in the following issues. Registration of sale deed by the holders of the power of attorney. The holder of power of attorney is only an agent for the principal in whose name the property stands. The activities of the power holder in respect of the specified property is limited to the provisions of the power deed. The proposal has power to cancel the power. Principal has the power to cancel the power document at any point of time. The power of the agent is limited to the lifetime of the principal. Any dealing of the agent after lifetime, the power of the agent is limited to the lifetime of the principal. Any dealing of the agent after the lifetime of the principal becomes invalid. The purchaser must avoid purchase from the power holder. Wherever it is possible, the purchaser must consult the owner of the property before purchase. In addition to that, buyer should go to the site personally and inquire with the neighbors and village officers regarding the ownership of land. Most of the fraudulent dealings in land are based for want of basic information on the part of the buyer people. Avoid false registration. Another area of fraudulent dealing in land is wantonly furnishing wrong or false survey number, subdivisions, patta, chitta, adangal and A registers in the sale deed. It is also for the buyer to investigate, inquire and satisfy the correctness of these items before payment. 3. Remedy for false fake registration. If the fraudulent dealing in the sale deed executed by the seller is found out by the buyer, correct method of remedy for the buyer is to approach the registration authority that has the judicial power of inquiry and bring the facts and place before him for the case. If the registration department is satisfied about the fraudulency in the sale deed of the seller will be called upon to give the by reply. If his reply is not satisfactory, the registration department will refer the case to the concerned police officers for taking necessary further criminal action for land grappling. The police will proceed on the seller for criminal action. Other issues are less fraudulent and less dominant, but more litigant dominant. 4. The importance of patta and certified copy of registration patta. Patta is given by the Tahsildar of the relevant taluk office. It is necessary to have patta for all land related issues. Without patta, the planning authority will not accept the planning for construction of building. In case there is no mother document, the buyer should have certified the copy of the document from the registration department. Ancestral property. In the case of ancestral property which has no mother document for the corroborative evidence, including actual possession, have to be ascertained. 6. The importance of encumbrance certificate. Encumbrance certificate from the sub-registrar office should be obtained minimum 30 years before buying any immovable property. Encumbrance certificate shows only the transaction that have taken place in sub-registrar's office in respect of said property, but no more value can be attached to the encumbrance certificate. Approval. 7. Approval of plan and loan. Approved layouts on building plan does not necessarily imply the title of the seller. Similarly, giving a loan by the bank or a financial institution does not guarantee the title of the seller. Settlement of self-earned property to blood-related family members. No settlement of property. Stamp duty of ₹10,000 plus registration fee of 2,000 has to be paid. 9. E-stamping. Under this system, purchase of too many stamp papers is avoided. It does have more advantages. Building construction, planning constructed in violation of planning and development rules have to be demolished at the extent of violation. But the building constructed prior to 13/11/2007 need not be demolished, as the Supreme Court order states status quo has to be maintained in respect of such a building. Try to purchase buildings which are not in violation. 11. The unapproved layout will not be allowed to be operated. 12. Fundamental rights. The property is not a fundamental right, but the land on one's possession cannot be taken away without inquiry as per Supreme Court order. 13. Floor space index, FSI. More than space to EWC housing project is allowed. Premium FSI will be related to road width. 14. Divorced women right. A woman after her divorce has the right over the husband's residential property as caretaker or custodian nature. 15. Urban Land Ceiling Act. The Urban Land Ceiling Act was enacted in 1975 or 76 and the Repeal Act in 1999. The excess land over the prescribed limit has to be taken over by the government, but most of the landlords coming under this act dispose of the excess land within the notice time, calling for 1 month time under section 4(1) of the 4(1) for any objection. Thus, the category of innocent buyer has come into existence. After Repeal Act, the innocent buyer purchasing such land for residential purposes not more than 1.5 ground were allowed to retain, but in 2011 instructed the urban local bodies not to give further regularization to the innocent buyers. All such lands taken over by the government has been notified under the government land. Registration office could not allow registration of government land, but some people fraudulently changed the survey numbers and the subdivision numbers and the registration of their property. Thus, it has created land grabbing, which has assumed unprecedented level, necessitating United Nations to give guidelines, and most of the buyers are badly affected for want of necessary information. 16. Survey. There is a separate department of the state government for survey of land called Directorate of Survey and Settlement. The department has 3 wings: Central Survey Wing, 2 Survey Wing, 3 Maintenance of Land Records Wing. Surveys are attached to the Taluk office. Village survey maps of land with measurement are to be available in Taluk office. 17. Any other issues related to the participant will be attended to by G. Ramasamy. Phone number 9840-722-301.
நம் தமிழகம் மட்டுமல்ல, இந்தியா முழுமைக்குமே பொருத்தமான இந்த அரிய விவரங்களை ஒவ்வொரு குடிமகனும் தெரிந்து கொள்ள வேண்டும் என்ற நோக்கத்தோடு இந்தியன் குரல் அமைப்பு வெளியிடுகிறது.